All right, let's jump right into today's explainer. We're diving into a situation that honestly sounds like something straight out of a spy thriller, but it's a very real-life collision of international law and secret operations. We're going to unpack this massive Washington Post report detailing alleged CIA drone strikes on Ecuadorian fishing boats. And as we do, we'll unravel the super complex legal architecture behind unacknowledged state actions. Because this isn't just about what allegedly happened out there on the water, it's really about how domestic laws can actually be designed to make accountability completely disappear. So, the Washington Post reported a string of 3 initial attacks back in early 2026, January 20th, March 17th, and March 26th. But the truly crucial date here? August 13th, 2026. That's when the Post finally published its report, attributing these actions to a covert CIA program. Now, notice this stark 7-month gap of absolute silence between that initial January strike and the August newspaper publication. That gap right there? That forms the inciting mystery of what we're looking at today. For over half a year, literally no agency, no government stepped up to claim responsibility. And the thing that finally closed that gap wasn't a government disclosure or some court ruling. It was a newspaper.
To set the scene for these Galapagos drone strikes, the Post reported that small quadcopter drones were dropping munitions or detonating on Ecuadorian vessels, and this followed surveillance flights coming out of El Salvador, specifically Ilopango Airport. It completely sets the stage for this massive legal mystery. This brings us to a really specific, almost hidden piece of legal architecture. Let's look at the exact term of art governing these shadows in U.S. law: covert action. Before a legal covert action can even occur under Title 50, the law requires 3 incredibly strict steps. It's essentially a legally mandated invisibility cloak. First up, the president absolutely has to make a written determination that the action is necessary to support foreign policy objectives and is vital to national security. And this is absolutely crucial. It cannot be retroactive. You can't just break something and then sign a paper later to make it legal. Second, this finding has to identify exactly which agencies are involved. And third, the Congressional Intelligence Committees, or in super extraordinary cases, a small leadership group known as the Gang of 8, they have to be kept fully and currently informed. Now, this creates a totally fascinating, almost mirror image contrast in U.S. law. Under Title 10, the military acts and the Pentagon takes the credit. There's an actual institution that stands up afterward and says, yep, we did this. But under Title 50 covert action, it's the exact same government, potentially happening in the exact same ocean, but with zero public admission. The weapon used doesn't change at all, just the paperwork does. So we've got to ask, what happens when a legal system is engineered from the ground up to have absolutely no public author? Well, the crucial point here is that this absence of an admission, it isn't just some public relations posture. It is exactly how the statute is designed to work. Think about what a family normally does when a state harms their relative, right? They identify the state, they file a claim, they seek an inquiry or maybe compensation. But every single step of that process depends on naming a respondent. If the law legally dictates that the state's role remains totally unacknowledged, that sequence never even starts. It means there is zero respondent state to name on a family's claim form. So the absence of a forum for these families, it's not a bug in the system, it's the defining feature of the law itself. To really understand how incredibly confusing this gets out on the water, we have to look at 2 entirely distinct ledgers running simultaneously in the Eastern Pacific. All right, so since September 2025, the Department of Defense has been running an acknowledged, totally public anti-narcotics campaign that's resulted in over 220 reported deaths. That campaign is debated out in the open. But the Galapagos attacks fall under an entirely separate, unacknowledged CIA program. In fact, the Pentagon specifically states that U.S. Southern Command had no role whatsoever in these strikes. So that leaves us with 2 separate campaigns in the exact same ocean. One public, one unacknowledged, yielding 2 completely different legal realities that look absolutely identical from the surface of the water. If a boat gets destroyed out there, an observer has literally no way of knowing which authority pulled the trigger. And here is where things get really tense, because this domestic U.S. law violently collides with established global rules. The global framework we're talking about is the UN Convention on the Law of the Sea, or UNCLOS. Its core rule, Article 92, is essentially the load-bearing wall of maritime law. It states that on the high seas, a vessel is subject to the exclusive jurisdiction of the state whose flag it flies. Now, the vessels in the Post's report flew the Ecuadorian flag. Therefore, an Ecuadorian flagged vessel with an Ecuadorian crew falls firmly under Ecuador's jurisdiction.
Under normal circumstances, if a foreign state harms that vessel, it would be pretty easily resolved through standard state-to-state diplomatic notes, an exchange of explanations, maybe even potential reparations. Let's dig just a bit deeper into UNCLOS. Article 87 explicitly protects the freedom of fishing. Article 110 says warships can only stop vessels without consent for very specific, extreme reasons. Think piracy or a false flag. But consider Article 108, which deals with suspected narcotics trafficking. International law strictly expects cooperation with the flag state, meaning the acting state absolutely must work with Ecuador. You can probably see the massive paradox here, right? How on earth do you cooperate internationally when your own domestic law makes it illegal to even admit you're there in the first place? This inevitably leads us to a huge question. If this whole thing is invisible to maritime law, where exactly is the accountability? Who in Washington is actually watching this? Well, the House and Senate Intelligence Committees are legally required to be fully and currently informed. And behind closed doors, in secure sessions, they definitely can push back. They can threaten to withhold funding or demand program modifications. But legally speaking, they cannot declassify a single word to the public or explicitly say what they know. So, the system might actually be functioning perfectly inside those secure facilities, but because members can't legally disclose classified findings, it looks identical to having absolutely no oversight at all from the outside. This perfectly explains why both the CIA and the committee members flat out declined to comment to the press about the Post reporting. Silence is quite literally the legally mandated behavior here. Ultimately, we have to ground all of this abstract legal theory in the stark, very real human reality for the families waiting for answers. 8. That's the number of Ecuadorian nationals aboard the 52-foot longline fishing boat called the Fiorella who did not come home from the March 26 strike. They remain missing today. Because of this massive clash between domestic secrecy laws and international maritime expectations, their families in Monte, Ecuador have no named respondent, no accessible claims process, and absolutely no public inquiry. Going forward, there are 3 really key potential developments you should keep an eye out for. First, watch to see if the House or Senate Intelligence Committees announce any form of review. Second, watch the government of Ecuador formally raises this matter as a state-to-state question. Under maritime law, they absolutely have the standing to do so, and asking would force some kind of a record. And third, above all else, watch for any government anywhere using the word acknowledged, because this entire legal deadlock and the family's inability to seek compensation shatters the very moment a responsible government officially acknowledges the act. But until that single word is spoken, the doors to accountability remain legally locked shut. So I'm going to leave you with this pretty provocative final thought to chew on. What exactly are the implications for global accountability when a legal system is intentionally designed to authorize lethal actions without any public obligation of admission? It's a really heavy question about the balance between national security and human rights. Thanks for hanging out with me for this explainer today, and keep asking those tough questions.